federal judge is rejecting the U.S. Justice Department's bid to unseal grand jury materials in the Ghislaine Maxwell case. Let's go to CNN's crime and justice correspondent, Caitlin Polantz. Caitlin, what is the judge saying?
Well, Wolf, the judge is outright rejecting the Justice Department's bid for transparency around the grand jury transcripts that were behind the indictment of Ghislaine Maxwell in 2021. The judge says that the Justice Department's arguments, they just do not fly. The Justice Department wanted to say there was special circumstances here of public interest to want these transcripts to come out. And the judge over and over again, this is Paul Engelmeyer in the Southern District of New York Federal Court. He says that just is not the case. It's not a special circumstance because there's not enough in these grand jury transcripts that would be new to bring to the public anything of substance.
Hi, buddies. Adam is here. What's unfolding inside America's courtrooms is the kind of legal drama that historians will study for generations. We're not talking about one big moment, one dramatic gavel strike where a judge announces the end of the road. No, what's happening is something far more methodical, far more surgical, and far more devastating to the defense position than any single ruling could ever be.
A major loss for Donald Trump at the Supreme Court is good news for democracy, but the bulwark that the judiciary is presenting in the face of Donald Trump's threats has been happening since the beginning of this administration, and it continues even in the face of increasingly threatening rhetoric against judges by the Trump administration. Take one of the most prominent examples, the D.C. District Court Judge James Boasberg, who last week issued a directive ordering the Trump administration to facilitate the return of any of the Venezuelan migrants who are now in third countries as a result of being unlawfully deported last March. If a migrant is sent to a so-called third country, it means they were sent to a country that they were not living in prior to coming to the U.S., nor to a country of which they are a citizen or a national.
We're watching multiple judges across multiple jurisdictions simultaneously slam shut every escape route that's been keeping the accountability machine from reaching its final destination. The Supreme Court said no. Federal judges said no. State judges said no. And while all that's happening, behind sealed doors, a federal judge is reviewing documents so sensitive, so potentially explosive, that the public has only seen heavily redacted versions.
And starting today, Congress members are now able to view unredacted versions of the evidence in Epstein's case. So far, the Justice Department has released more than 3 million documents. Can you break down what's happening and how this release is working?
Yeah, Mugo. So we know from the Department of Justice that at least 2 lawmakers is headed over this afternoon to take a look at those unredacted files. This is something that Trump administration officials said is available at their behest because there's been bipartisan concern over whether or not the Trump administration has been slow walking the release of this information after Congress passed a law and the president eventually signed it into law, compelling them to do just that.
Documents that the Department of Justice itself admits contain accusations directly involving the man at the center of it all. This isn't speculation. This isn't punditry. This is the documented record of what courts have already decided, and it's more alarming than any fictional courtroom drama could ever capture. The path that leads to prison is being cleared, not by one dramatic order, but by the accumulated weight of judicial actions that are systematically eliminating every procedural barrier that's been standing in the way.
After Boasberg's earlier ruling in favor of the rights of the Venezuelan migrants, Trump posted on Truth Social almost a year ago, calling Boasberg a, quote, radical left lunatic of a judge, a troublemaker and agitator who was sadly appointed by Barack Hussein Obama. Trump went on to say, quote, this judge, like many of the crooked judges I am forced to appear before, should be impeached.
Let me take you inside exactly how this is happening, because the story behind the headlines is far more consequential than anything you've heard. The first and most constitutionally significant development came from the highest court in the land. The Supreme Court refused to step in and block Trump's hush-money sentencing. Now, you need to understand what that refusal actually means. When the Supreme Court declines to intervene, it's not just a procedural shrug. It's a specific institutional assessment that the arguments being made don't rise to the level that warrants the court's extraordinary power to stop ongoing proceedings. What was the argument they were being asked to accept? That being president-elect, preparing to assume the duties of the office, creates a constitutional shield that should protect someone from criminal sentencing. That the demands of transitioning into the presidency are so weighty that they override the normal operation of the criminal justice system. The Supreme Court looked at that argument and said no, not maybe, not we'll think about it, no. In the most authoritative format available to American jurisprudence, the highest court in the country rejected the theory that political status creates constitutional protection from criminal accountability. That rejection is permanent, it's in the record, and it establishes a constitutional baseline that every other court will now apply. Political achievement does not immunize you from criminal consequences, even at the very moment of your highest political success. Think about what that means. A defendant who cannot get the Supreme Court to protect him from sentencing during the period of his greatest political power has exhausted the most powerful procedural protection available. That exhaustion is itself the clearing of a path that was previously blocked by the possibility of Supreme Court intervention. But the Supreme Court refusal was just the opening move. While that was happening, a federal judge in another proceeding delivered a ruling that cuts to the very heart of the delay strategy that has been the foundation of Trump's legal defense across every case. The judge rejected Trump's request to push his criminal trials until after the election, and the language of that ruling is what makes it so devastating. The judge specifically stressed that running for office gives him no immunity from prosecution and no special scheduling treatment. No immunity. No special treatment. Those are the words on the record from a federal judge. Here's why that matters so much. The entire delay strategy has been built on the theory that Trump's unique political position justifies special judicial accommodation, that the demands of campaigning and holding office create a legitimate basis for courts to grant delays they would never grant to an ordinary defendant. The federal judge looked at that theory and rejected it in the most explicit terms available. No immunity from prosecution means the legal accountability proceeds regardless of political status. No special scheduling treatment means the calendar of the justice system does not bend to accommodate the calendar of the political system. And the specific collision between trial dates and campaign season that this ruling locks into place is now described by the court itself as a political inconvenience rather than a constitutional barrier. The judge locked in trial dates that go straight through campaign season. The justice system timeline is now proceeding on its own schedule, not on the schedule that political convenience would prefer. And without the special treatment that the delay strategy requires, the entire foundation of the defense's procedural approach collapses. The trial dates are set. The accountability clock is running. Then came the third closure, this time from a New York judge handling the hush money conviction. Trump's legal team had been trying to move that case from state court to federal court, a jurisdictional escape route designed to take the most advanced criminal conviction they face and shift it to a forum that might be more sympathetic to dismissal or delay arguments. The strategy was specific. Get the case out of the state court where the 34-count conviction was obtained and into a federal court where different procedural rules and different judicial dynamics might produce a different outcome. The New York judge looked at that attempt and ruled that Trump waited too long, too late. The procedural window for removal had closed. The attempt to shift jurisdiction came after the critical juncture in the state court proceedings where such moves are still available. The ruling blocks the escape route entirely. That means the 34-count guilty verdict remains in place in the specific court where it was obtained, with the specific sentencing structure, unconditional discharge, that preserves the conviction while the appeals process proceeds. The jurisdictional escape route that was supposed to provide a second chance in a friendlier forum is now sealed shut. The conviction stands where it stands, and the appeals process will determine its ultimate fate in the court system where it belongs. Now here's where the story takes a turn into territory that's even more explosive. While all these escape routes are being closed in open court, something else is happening behind sealed doors that could prove to be the most consequential development of all. A federal judge in New York has been reviewing fully unredacted Jeffrey Epstein documents. No black bars, no missing names. The full, unredacted files that the public has only seen in heavily censored form. The Department of Justice itself has acknowledged that some of these documents contain accusations involving Trump, while also noting that certain claims may not be true, which tells you exactly how contested and how explosive this material is. Let me be precise about what this means. The public has seen approximately 3 million pages released under transparency laws, but those releases came with extensive redactions, names removed, identifying information blacked out, claims and accusations that could be tied to specific individuals hidden from public view. But a federal judge is now reviewing the unredacted versions, the complete files, the material that the DOJ has been withholding on grounds ranging from privacy concerns to ongoing investigation protection. And the judge is doing this review in a sealed proceeding. No public pressure, no political controversy driving the narrative, just a judicial officer evaluating the evidentiary merit of the complete, unredacted record, including the specific names and accusations that the redacted public versions hide. Here's why the sealed character of this review makes it more consequential rather than less. The public debate about the Epstein documents has been shaped entirely by the redacted materials, the version of the story that the DOJ decided the public could see. But the judge sees everything. The complete picture, the full context, the specific documentary evidence that connects accusations to individuals. If the unredacted materials contain corroborated accusations that would support specific legal actions, the sealed judicial review is exactly the proceeding where that determination will be made. And any action that comes from that review, any accountability outcome that emerges from a judge who has seen the full unredacted record, would represent the next seismic development in the overall prison path story. The February reporting that this review is actively underway, combined with the DOJ's acknowledgement that the documents contain accusations involving Trump, establishes that the most consequential pending judicial proceeding in the entire accountability picture is currently in progress behind closed doors. Now let me connect all of these pieces together, because the prison path the headline describes isn't any single one of these developments. It's the accumulated effect of all of them happening simultaneously. Start with the hush money conviction, 34 counts, guilty verdict. Confirmed and in place, surviving both the Supreme Court's refusal to intervene and the New York judge's block on removal. The appeals process will determine its ultimate fate, but the conviction itself stands as the permanent criminal record of the first convicted president in American history. Move to the classified documents case. The Mar-a-Lago recordings, the surveillance footage, the witness testimony that Jack Smith's team assessed as sufficient to sustain a conviction. That case is waiting for the political conditions that would allow prosecution of a sitting president, or waiting for the post-presidency window that would allow prosecution of a former one. But the evidentiary foundation is already built. The accountability machinery is already in place. The election interference case follows the same pattern. The testimony, the evidence, the overall record that prosecutors have been building for years. Waiting in the same condition as the classified documents case, ready to move forward when the political conditions permit. And now, on top of all that, the Epstein documents review adds a new dimension. A federal judge reviewing the most sensitive available materials, forming an independent assessment of the complete unredacted record, potentially positioned to take actions that could add entirely new accountability pathways to the overall picture. The combination creates something that no single ruling could create. One conviction already secured. Multiple cases with sufficient evidence assessments ready to move. Escape routes being closed across multiple proceedings simultaneously. The most sensitive available materials under active judicial review. This isn't speculation about what might happen. This is the documented record of what courts have already decided and what they're actively doing right now. The Supreme Court's refusal to block sentencing is the constitutional foundation of the entire prison path. When the highest court in the country rejects the argument that political status creates immunity from criminal consequences, that rejection echoes through every other proceeding. Every lower court judge applying the same principle starts from that baseline. Every defendant who might have hoped for Supreme Court protection in the future sees that hope extinguished. The refusal is permanent. It's in the record. And it establishes that the prison path is constitutionally open regardless of what office anyone holds or seeks. The federal judge's no special scheduling treatment ruling is the practical engine that accelerates the accountability timeline. The entire delay strategy has depended on courts granting special accommodations based on political status. That ruling explicitly denies those accommodations. No immunity, no special treatment. The trial dates are locked in. The justice system timeline proceeds, and the collision between those dates and the political calendar is now officially described by a federal judge as an inconvenience rather than a barrier. Without the special treatment that the delay strategy requires, the remaining procedural options narrow dramatically. The unredacted Epstein documents review is the single most consequential pending development in the entire picture. A federal judge reviewing the complete files, no redactions, no black bars, no missing names, in a sealed proceeding free from public pressure, is the specific scenario most likely to produce actions based on evidentiary merit rather than political dynamics. The DOJ's acknowledgement that accusations involving Trump exist in those documents confirms the explosive nature of the material. The sealed character of the review means the judge's assessment will be based on the full evidentiary record, not on the incomplete picture the public has seen. Whatever comes out of that review, whether new accountability actions or a determination that the accusations don't support them, will represent the next major development in the prison path story. Here's what we need to watch as this continues to unfold. The appellate resolution of the hush money conviction is the most immediately consequential pending outcome. A final affirmance would cement the 34-count conviction as the permanent criminal record, completing the most advanced dimension of the prison path. The sealed Epstein review outcome is the most consequential pending development in the potentially explosive materials dimension. Any judicial action based on the unredacted documents would add an entirely new layer to the accountability picture. And the Georgia RICO case, operating on its own timeline independent of the federal prosecution barriers created by presidential status, represents the state-level dimension most likely to produce active trial proceedings in the foreseeable future. Here's the bottom line on everything we've covered. The Supreme Court refused to block the hush money sentencing, rejecting the theory that president-elect status creates constitutional protection from criminal accountability. That refusal is the most authoritative available institutional statement that the prison path is open regardless of political status. A federal judge ruled that running for office gives Trump no immunity from prosecution and no special scheduling treatment, locking in trial dates that collide directly with campaign season and rejecting the political calendar escape route that the delay strategy depended on. A New York judge ruled that Trump waited too long to remove the hush money conviction to federal court, blocking the jurisdictional escape route and leaving the 34-count guilty verdicts in place in the court where they belong. And a federal judge in New York has been reviewing fully unredacted Epstein documents, no black bars, no missing names, with the Department of Justice acknowledging that some of those documents contain accusations involving Trump, creating the most consequential pending judicial review of the most sensitive available accountability materials. The prison path isn't one dramatic moment. It's the accumulated closure of specific escape routes. Supreme Court refusal, no special scheduling, removal blocked, sensitive materials under review, until the remaining available paths are the ones that lead directly toward the accountability outcomes that the documented record supports. Stay tuned. The appellate proceedings are active, the sealed review is underway, the Georgia case is building, and we're going to be right here covering every single development as it unfolds.